Well, welcome everyone to today's webinar. Today's webinar is sponsored by our partner, Superlegal. Superlegal is an AI law firm designed to help construction companies review, negotiate, and manage contracts more cost effectively. Before we dive in, we're going to give everybody just a few minutes to switch between meetings, get connected, get their audio hooked up. And as people are doing that, I wanted to just briefly talk about the American Institute of Constructors, AIC. Our organization is providing the webinar content through our sponsor, Superlegal. For a little bit of background on AIC, since 1971, AIC has been dedicated to promoting the professional development and recognition of those involved in the management of construction process. Through our two professional certifications, the CAC, which is the Level 1 certification, and the CPC, which is our Level 2 certification, constructors gain credibility to manage complex projects. As we're going through the webinar content today, we ask that if you have any questions that you submit them through the Q&A feature, which you should be able to find that button at the bottom of your Zoom window. If you ask them as we're going through the slide content, I will ask our host or our presenter to answer those questions as we're going through. And for anything that we can't get to as we're going through the slide content, we will allot some time at the end of the presentation for Chris to take additional questions. So with that being said, I want to introduce our presenter from Superlegal. Our presenter is Chris Lewis. He's going to take a few minutes to introduce himself in a little bit more detail, but Chris is the Vice President of Legal Operations at Superlegal. And like I said, I'm going to let Chris tell you a little bit more about himself as he gets started. But I think with that being said, we're ready to get underway.
Excellent. Thank you. Well,
Mm-hmm.
it's a pleasure to be here. As mentioned, I'm Chris Lewis. They made a little slide for me uh, to talk about my experience. I have about 25, 26 years experience in real estate business law, including construction litigation, construction contract negotiations, and representing all sorts of parties in those. I do litigation and contract drafting. And so I hope to bring a bit of a practical element to our discussion today based on that experience. I, of course, don't have your experience, so I'm hoping that it translates well to your daily workflows. I hope it's useful because when we talk about construction contracts, there are a lot of pain points, right? We deal with for those of you who are involved in the negotiation process, in the approval process, in reviewing terms, which is, I assume, everybody here, um, it's not an easy thing. You want to close a deal, but you also want to limit exposure. And balancing those two things is a real challenge. So hopefully we can demystify some of those issues. This, as you saw at the beginning, this is the title of this is Black Swans and Contract Review, Navigating the Unthinkable. So just to remind us all what a black swan is, it's just it was originally coined before they realized that in Australia black swans actually existed. The notion was that it's such a rare event that it's it's unpredictable, right? And when we deal with improbable, unpredictable events of high impact, we we're probably first of all talking about your day-to-day work in a lot of ways, especially if you're doing construction management on site, if you're dealing with workflows, if you're dealing with a lot of subcontractors or a lot of different parties, that can be controlled chaos. And so this presentation isn't designed to increase your stress levels. Hopefully, provide some practical ideas about how to manage them. But I recognize that operations and especially construction operations, I can't imagine anything more operationally complex than what you do. And so I come in recognizing that it's a very real issue. We've seen in recent years some of these issues really take center stage. Uh, COVID-19 created a lot of disruption. Uh, Sudden tariffs imposed have created a lot of financial burdens and supply chain issues. And I'll tell you, at least from the legal standpoint, a lot of legal teams were caught off guard with how courts managed, how judges manage some of these issues, which I'll talk about because I think it's relevant. I don't want to dwell much on, litigation or arbitration, but it's good to be reminded of what the outcomes can be because that's where the rubber hits the road on a dispute if you can't resolve it internally. But hopefully you can. So in the legal world, we we need to acknowledge that, and very much in your world, is that no matter how predictable a bad event is that disrupts your day or a major project entirely, they're still unpredictable, right? Unpredictable events are predictable. There's kind of a paradox is COVID-19, we all knew from the Spanish flu in 1918 that worldwide pandemics can happen. So it wasn't news to anybody, and yet it was unpredictable in the sense that it was not business as usual. It was not something anybody foresaw, and the disruption was utterly chaotic, both from an operations standpoint for all of you and from a legal standpoint as courts tried to navigate the chaos. So I'm going to talk about various contract areas today. One of them that you'll hear the most about is force majeure. So just to recap for everyone's benefit what force majeure is. First of all, it comes from the French. It just means a major event, a superseding event, something that's legally implies it's disruptive and unforeseen. So traditionally, what that meant was basically acts of God, right? The things that we say that no man, no person uh, caused earthquakes, floods, wildfires, tornadoes, hurricanes, tsunamis. I've got listed here, but it has expanded beyond acts of God to things that are human generated, like war, terrorism, government actions, labor disputes. Disease is heavily influenced by people and their interactions with the environment. So force majeure went originally from acts of God to a much more expansive notion of uh, what can disrupt the flow of somebody's work. Now, force majeure clauses aren't just concerned with identifying those, but excusing non-performance or excusing delay based on those causes. And it's, as you know, very serious in managing a site and managing a contract. You've all seen, I think, where these events have affected us historically, and maybe actively on current projects. But they're real concerns and they can result in the termination of the contract or the temporary suspension of the contract. So that's the brief background as a reminder of what we're talking about here at first. What COVID-19 taught us is that we don't really know how courts are always going to interpret a clause until it really gets heated. And I'll discuss that more in a moment. But courts are reluctant to allow delay and termination of a contract based on force majeure unless the event is specifically identified. We'll address that more in a moment. So a catch-all, like the parties are excused from performance due to anything beyond the control of either party, is of limited value. It's useful, but we need to also consider all the events that we want excuse for, or we want to limit that list, depending on which side we're negotiating the contract. I think many of you, if not all of you, are in organizations or in roles where you both are the service provider, right? And the service recipient. For example, if you have a supplier or subcontractor under you. And so there's an inherent friction. And I think one thing that we ought to tuck away and keep in mind as we further this discussion is ethical and fairness considerations as we navigate these terms. What's useful for if a clause is beneficial to you as a service recipient, then it should be a similar clause to what you can use as a service provider. If there's a wide divergence between what you're willing to have, depending on what side of the contract you're on, you might want to consider whether that's a fair allocation of risk. And those are real considerations. We do want balanced, reasonable provisions that address legitimate logistical concerns and interruptions without going too far or not far enough. So when we talk about force majeure, we're talking about when performance under a contract is impossible on one hand, impracticable on another hand, or merely hindered. So there's kind of a spectrum. Impossible, you can't do anything. Impracticable means that putting it into practice is interfered with. It's hard to implement. It's very difficult, very challenging. Maybe the pricing or the scheduling is very difficult, but not quite impossible. Hindered is a lower standard. If your performance is hindered, then it could be a hiccup, right? So the words in the clause matter, and we'll revisit that. But a lot of what I'm going to say is obvious, but sometimes you have to restate the obvious. And so words matter. I'll say a lot of trite things like that, but hopefully illustrate in a way that makes it meaningful. So causation is important. So the link between the event and the non-performance issue. So to give you an illustration, when COVID-19 came, a lot of us were performing remote work. I mean, when I say us, I mean people in the United States. A lot of people sat at a desk. A lot of people were electronically wired, and other people had jobs that required their physical presence somewhere. And most people have jobs like that, I think, where physical presence in a particular location is essential and human interaction is essential face to face. And so COVID-19 had different effects on different job types. For those who were already remote and electronic, they could not use COVID-19 to the same extent as an excuse as those who had to be on site. Also, companies or individual workers who relied less on other people and supply chains and coordinating work with other people were less affected by than those that did. So not everybody's impacted the same way. So not everybody can use COVID-19 as an excuse in the same way. So if a force majeure clause in a contract excuses non-performance because of pandemics, and if you're in the midst of COVID-19, You can only claim it if you are actually compromised in your ability to perform. Again, that sounds obvious, right? But courts really dug into this when we saw litigation coming out of COVID-19 performance disputes. So courts differ on whether an event must be unforeseeable. And I don't know how old the audience is, but when I was a kid, I ran across a TV show called Kung Fu, and it was about some guy walking through the West in late 1800s who was a Kung Fu specialist, uh, and constantly getting in fights. And I guess it appealed to 10-year-old boys mostly. Um, the his wise mentor at his Shaolin monastery in China always told him, expect the unexpected. And that's great, expect the unexpected. It's also impossible. You literally can't expect the unexpected. So how do we foresee the unforeseeable? So where some courts say it has to be unforeseeable to be protected, like the event. An earthquake couldn't have been foreseen in order to get relief under a force majeure clause. How do you then navigate? Because earthquakes are inherently foreseeable, because I'll tell you right now, they can happen. So now it's foreseen. Uh, so you have to think carefully. You you also want to make sure the clauses address specifically that things are outside the control of the parties, and you want to try to list at a minimum the event because you can't control what the court is going to do. So we'll talk about some of these considerations.
So, Chris, we actually have a
Yeah,
question from one of the attendees that I wanted to
great.
ask you because it's tying to force majeure. So the question is, can very serious inflation in an economy still be considered as a force majeure, or what you're currently referring to as a black swan event?
Excellent question. And actually, you are foreshadowing where I'm just about to go. But let me answer briefly. To to talk about inflation generally as a force majeure event is harder than it is to discuss it as a black swan event that can be treated in other ways. So basically, inflationary impacts are not considered force majeure events. Until they reach a certain level, then you can argue they might be. So I'm not trying to be obscure there. But as we dig into this discussion a little bit more, when we talk about tariffs, it's a similar analysis. So what I say about tariffs will apply similarly to that question. So it's a very good question. And if you feel it's unresolved at the end, please re-raise it and we can then look retrospectively back at what we discussed and we'll have more context to address that.
Yeah, that's a good idea because he did give a little bit more information about the scenario, but
Okay. Well,
I'm gonna
can I hear
he
that?
yeah, I'll read that. He is saying thanks for the answer, so I think you did answer his question, but just for the rest of the attendees, I'm gonna elaborate on his question. He said, I asked because I was on a project which till today hasn't been 100% completed. Inflation had a role in it being not always getting approved for newer valuation for the project to be considered. It was never approved for a yearly budget allocation from the client again, even though in the first bid amount, full payment had never been completed.
Got it. So you're yeah, you're kind of in a complex scenario there. And I will be addressing some things that are relevant to that discussion. I you kind of have a dispute issue on your hands because you've got layers of issues that aren't directly related to the inflation, it sounds like. And so that is a sticky situation. Uh, Hopefully, some of what I say will give practical tips about what to do in a dispute situation like that and address the general idea of when costs get changed by black swan events. And it's a good time to illustrate because that question carefully recognized the difference between force majeure and black swan event. But I want to maybe take the opportunity to clarify that that's right. They are different. A force majeure clause is one way of attempting to address a black swan event, as that question acknowledged. And a black swan event itself is anything that is unforeseen. So wonderful. Um, let's talk about tariffs and trade policy shifts. This is something that this should say earlier last year. This wasn't this year. But uh, we saw protective tariffs, import duties that were just devastating. I've talked to many people in the construction world, and almost uniformly they say it affected them. So probably not newer businesses if I'm thinking of exceptions, but what do we do in those situations? We saw material costs soaring, steel, aluminum, lumber. Uh, we, 6 to 10% rise. There's so many variables that go into that percentage. Supply chain disruptions. So when you have a material cost increase, then it's going to disrupt the supply chain because of supply and demand. Increased labor costs. Fixed price contracts were particularly hit hard, but not only those. So if you're bidding X dollars on a job, but your materials now cost more than your margin of profit, that's brutal. And I've talked to people where that happened, and we know the profit margins are fairly thin on most construction projects. It's incredibly competitive. If you have a unique situation, you've got a unique product, unique construction services, unique expertise, then you might weather that storm a little bit better, but it can be very challenging. And then a lot of planning and bidding uncertainty. How do you bid on this job knowing that the political climate is such that things can fluctuate quickly? Or to go back to uh, the inflation question, that we know that the social and economic climate are such that we might see spikes in inflation still ahead. So to the person who asked the question, what one thing I am going to highlight in this is how we learn from past issues. So that current job you're on, we need to learn all we can from that moving forward. So there are multiple things, not just force majeure clauses, that can help. A price escalation clause is important. And what I'm seeing most frequently is that there's some percent. So if the costs of materials fluctuate by a certain percent, say 5 or 10%, maybe 7%, then you revisit the pricing. So a price escalation clause is a great way to try to address that when there's a big variation. So you're absorbing some of the risk, but not all of it. Now, I've been focusing heavily on where you're contracting with perhaps an owner or somebody where you're the service provider, but also looking at subcontractors, looking in the other direction. And I'll shift back and forth, but the principles are the same. The strategies might be different. But if you're looking down at subs, I think you need to make sure that what you're engaging them, what terms you're engaging them on, are something you can cover with your prime contract or with a other contract you're dealing with. And so you need to align them. So if you have a price escalation clause and you're not willing to grant it to a sub, there's a little dissociation there, right? But if you do have one with the owner and the sub is asking for better terms, you also have an alignment issue. So those obviously, I mean, again, I'm speaking the obvious, but these are things that become critical components and sometimes can be easily overlooked when you're negotiating a contract on the fly, dealing with very difficult counterparties. It's tricky, right? You know that. And You can have material specific triggers like iron, aluminum, imported steel, lumber. You can specify, and your industry, it might even be mineral based, a specific mineral that you need. So, what events are covered? Are tariffs covered by, in your force majeure clause, the term government action? Are they covered by supply chain disruption? Are they covered by, you know, unpredictable events as a general category? I would recommend specifically addressing it in a force majeure clause as well as in a price escalation clause. Hit it from as many angles as possible because let me say this. I'm in my 27th year of practicing law. I've done litigation, a lot of courtroom work, and a lot of contractual negotiations, and a lot of managing of disputes that are pre-litigation. And what you've seen and what I've seen is the same. You don't want to win at arbitration and in court only. You want to avoid it. You want to get the project rolling. You want to have practical resolution. You want to work it out. I'll mention some of those things later, but you want as many parts of the contract as possible to give you a good discussion point, to make the counterparty think it's not worth going to arbitration or litigation and incurring that cost and time. There's enough in this contract that we feel the need to come to the table and have a reasonable discussion. Now, not everybody's willing to have a reasonable discussion. Hopefully you are. I think there are ethical considerations about good faith dispute negotiation and being reasonable and not just trying to shift responsibility to other parties, but trying to share reasonable responsibility. But as I note here, they're not just economic or political issues, these are contractual and legal issues. The way that US courts view it, and worldwide, basically it's uniform now, is we've got public law, statutes, acts, and we have private law, which is contracts. And the courts honor private legal arrangements between the parties and enforce them. And that is where the rubber hits the road. Like I said before, that's where unresolvable disputes are resolved, often to the chagrin of both parties. Sometimes both parties, even the winner, is in deep regret. So uh, I'm a big fan, despite making a living off of being in court. I'm a big fan of avoiding it where it's possible. And where you can't resolve it, all it takes is one unreasonable party, then it's perfectly legitimate to resolve it formally.
So, Chris, there's another follow-up question here, if you wouldn't
Great.
mind going back to that
Sure.
previous slide.
Yeah.
How do you have any, are you seeing these price escalation clauses as more common, and do you have any, I guess, tips or best practices about how to introduce that type of clause if it's not a standard part of your agreement so that it's a really competitive environment and just making sure that that keeps you competitive as a contractor?
Yeah, so we're looking from the service provider standpoint with that question, where we're probably engaging with an owner or somebody. So it could be a developer, it could be a government entity. But yes, I'm seeing that more and more an issue. It's negotiated. And I look, you're going to have different experiences with your business and who you deal with. But what I have found is very effective is not big explanations, but simple phrases like, we can't accept this risk. It exceeds our profit margins. We're in a volatile economic climate. We've seen it. This is going to kill us. We're just asking for you to come to the table when extreme events happen. And so that is my recommendation of how to address it is everyone says mano a mano, right? We address it head on. We address it in practical terms. A problem I see, and you've probably seen this with legal professionals, is they try to get cutesy with, threats or legal explanations. I think practical, hands-on reasons for needing a price escalation clause is great, and they want you to, right? It may be a competitive bid scenario, but they want to engage you. And so using the clout of this is going to kill our profit margins if we can't have this, I've found is pretty successful. You're going to run into unreasonable parties. And you guys see it maybe even more than subcontractors see it, is just dealing with very unreasonable demands and expectations. But I would just say, just own it that it's going to destroy your business and you need some consideration. Um, Pandemics and global health crises. I've talked about this a little bit, but based on our research in the 10-year span prior to COVID-19, there were fewer than 500 federal cases that brought up force majeure. So cases that have been brought to court and then appealed on some basis. Fewer than 500 dealt with force majeure claims. None that we saw dealt with pandemics or national health crises. So that's mind-boggling, right? I mean, I guess it's not. It's not mind-boggling that pandemics hadn't happened in those 10 years because we already know there was no global pandemic during that time. But none of the clauses mentioned pandemics or national health crises, and that's surprising. So since COVID-19, in fact, immediately after COVID-19, hundreds of new cases came out. And basically most courts said, if you don't mention pandemic, epidemic, or health crisis or something like it, you're out of luck. It's not excusing your performance. That has devastated some companies, and maybe some of you were involved with that devastation. So let me just say, word to the wise, brass tacks here. Mention epidemics, mention pandemics, specifically mention COVID-19 because the pandemic is over, arguably, but the disease isn't. Quarantine, public health emergency, think about terms you can put in there. Now, you don't want a full page force majeure clause. I dealt with one a couple of weeks ago that was almost 2 pages long in like what, 12 font. But you do need to mention something related to disease at a minimum. So you want to pare it down, but you've got to think disease if you want a court to recognize disease as a basis for excusing non-performance. And similarly, dealing with subs, if they come up with some of these things, make sure it aligns with your prime contract or construction management contract, and make sure that it is fair. You know, if you want reasonableness, I say extend it. Be reasonable, be thoughtful. I'm going to shift gears here
Oh,
because I'm
Chris,
looking. Oh,
before you
yes.
shift gears, there is a follow-up question to your previous slide.
Okay.
What could you help with a counter argument to an owner who isn't open to including this type of language in,
Yeah.
yeah.
First and foremost is I would say maybe in slightly politer terms, get with the times. COVID-19 bankrupted countless companies. You are the only counterparty I've dealt with who's giving pushback on this. It's an extreme position. It's not market standard. Get with the times, or we're going to move on to the next project. We have other people knocking at the door. I'm not saying be that blunt and that harsh. Maybe you need to be if they're already saying that, but be needed. Don't underestimate how much they need you, even if it was a competitive bid scenario, and also know your risk tolerance. Uh, what if another pandemic broke out tomorrow? Can you live with that contract? And maybe you can slide something in that's subtle. Um, you can work it into another clause. It doesn't have to be called a force majeure clause, but in the time is of the essence clause, where you talk about maybe accommodating for delay and cost adjustments, schedule adjustments, you can put in including those caused by external events like pandemic. You can get creative. The key is to have it in there, but I recommend strong pushback. I more often see, I think my clients underestimate the power of their position than overestimate it. We do have people lose deals because they're not cooperating. I would argue that sometimes those deals were okay to lose. Sometimes they're devastating and they're not. And you don't know. Sometimes people just walk out the door and they're not bluffing. We can't control other people's behaviors, but you can make sure that you're being principled. And the economic times, the industry standard is to have accommodation for force majeure. I see holdouts. I know that the high bargaining position companies are holding out and fighting back. Uh, but you can also say things that what we call feed forward in the negotiations world, where you take a hard stance, but then hint that you're willing to talk. And you can say that this is a devastating deal breaker. I'd need to get management approval. Or maybe you can suggest other language that addresses the issue. Often they have fallback language in their database that they've used before. And if you push back enough, they'll cough it up, but only until you get to the second or third level of negotiation.
Okay, thank you.
Okay, I'm gonna glaze through this one a little bit because I'm looking at the clock. I want to be respectful of people's time here, and I have about 15 minutes and most of my slides left. So I'm just gonna say cyber attacks and data breaches are real problems, and where that often will affect you the most, this audience, is business email compromise, BEC, where where people are attacking payment streams, intercepting payments. Just let me just say, cyber attacks and data breaches are real. They're a $1.5 trillion industry last I checked. Uh, and I don't know how you can totally quantify that. Ransomware, ransomware is a real thing, where somebody takes over your computer and you have to pay to get access back. So redundancies and storage, things like that are helpful. But as far as uh, listing it in a force majeure clause, mention cyber attacks. That's my advice, and I'm going to move on. I wish I could talk a little bit more about that, but I think that'll have to do. Just realize that sometimes who causes cyber attack is hard to know because it could be a government action. It could be a foreign effort at war we saw between Ukraine and Russia is that a lot of people have especially attacked Russia with cyber attacks in retaliation, but whether those are sponsored by Ukraine or not is unclear, and many claim not to be. And so is that a government or war-related act or something else? And the big safe thing to do is mention cyber attacks and data breaches as causes for your non-performance. They may interrupt your work substantially. Um, Let me talk about climate change, and I'm going to be quick on this one too. But with climate change discussions, and I know there are different opinions on whether climate change is human caused or not. I make no distinction here, is just realize that public uh, public law is looking at regulating the human side of the equation. So Clean Air Act, Clean Water Act, Kyoto Protocol, Paris Agreement. There are a lot of discussions on, water restrictions, energy caps, construction is being interrupted. Extreme weather is increasing, whatever the cause. And so it's a real disruption to supply chains and to work, but also to, infrastructure. So I would say you should anticipate more government interventions in the future. The trend is toward more regulation, and your contracts need to take into account climate risk and policy realities, no matter what your political opinion is. These are practical considerations, not merely, you know, a disagreement about the cause and policy and science. I'm going to spend a little more time on insolvency and mergers and acquisitions. So when you're dealing with a company, I would say your first line of defense is do some due diligence on the company. Are they stable? Do they have a history of using bankruptcy to solve their problems? Are they financially sound? Do they have a history that shows that they're a competent, well-run business? Or are you dealing with a high-risk business? I'm not saying you can't deal with high-risk people, just be aware that insolvency is a possibility, or the likelihood that they get acquired. I've had clients that are huge, huge construction companies that have been acquired by huger ones. So acquisition happens, and how does that affect your contracts? And that's a whole nother webinar. I'm not going to talk about that, but I'm just going to talk about it in light of our discussion today is that can be a black swan event, something that you didn't anticipate and that your contract isn't well uh, capable of addressing. So you can have what you may not know, I don't know. It seems like a lot of attorneys don't know this. Maybe you're savvier, but uh, when you have an insolvency law, the bankruptcy code, it overrides what goes on in a case. So you can have a strong contract and strong factual case, and you can win it. And the second that they invoke bankruptcy laws, you might have the whole case stayed, paused, suspended during the resolution of the bankruptcy proceeding. And you might find yourself in a position that you don't recover anything. So always do your due diligence on a counterparty to the degree of your risk. If you're contracting with an owner, that becomes critical. If you're dealing with a subcontractor who's doing minor work in a minor, area and it's outside the big scope of the contract, it's not a big legal risk and you can find replacement work easily, maybe that's not as much of a concern, but you need to think about these things and plan for them. And I'll talk about that more in a moment. Um, so be aware of the concern and make sure that your contract gives you termination rights in the event of insolvency. And if you're contracting with an owner and it gets acquired, how does it affect your contract? I'm just putting that as an aside, but termination rights is great. And then clearly define the effects of termination, like upon termination, blah, blah, blah. What are the effects? How do you address it? Okay, yeah, we're in the final 15 minutes here. In fact, I'm going to try to wrap up in 5 and leave time for questions at that point. Uh, just be aware that war can be a black swan event. It can be a force majeure event, and it can really disrupt things even when it feels far flung. And Russia's invasion of Ukraine is a prime example that interrupted the world economy, even though it's arguably a regional dispute. And dispute, I don't mean to under a regional war. Um, so construction contracts can see supply chain disruptions, contract interruptions, government actions, operational disruptions, labor shortages, all related to an act of war. And so, how do we define war when the U.S., several presidential administrations called the Vietnam War a political action or a police action? Uh, does that change how they define it? Uh, These are considerations attorneys need to make, and you need to when you're negotiating a contract, is wars and things like it, or wars and terror events. You just want to be specific. I'm going to get down into a quick wind down here. I actually have like 10 slides on this. So what are our takeaways? Uh, I would like to say that have a good force majeure clause. Consider the events that you think will disrupt your business the most. If your if your business isn't going to be affected by hurricanes, no supply issues, no work issues, then it's less important than things that will affect you. So you need to be strategic and not just take boilerplate language. Um, you need to think about suspension rights, termination rights, notification and mitigation requirements. Those are big for you guys. If you've got to notify within 7 days and you're dealing with a chaotic work site, for example, if you're a construction manager and you're dealing with putting out fires all day, you might not notify in time. That might be the back of your mind. You also have to mitigate damages. When you have a legal excuse for poor performance or non-performance, uh, you your counterparty still has to mitigate their damages, and you as a service provider need to mitigate. So you need to minimize harm to you, and that takes planning. If, for example, if you are going to use the excuse that your supply chain was disrupted, and you have supply chain disruptions as a force majeure event, have you attempted to mitigate damages by finding other suppliers? And have you done contingency planning before you entered into the contract for backup suppliers in case the supply chain is disrupted? Those are critical considerations. Planning, getting people in a room can be very hard in your industry because it's so operationally intensive. You don't have the luxury of having unnecessary meetings, but your next team lunch, you can really sit down and talk about contingency planning, and it's worth your time. Uh, yeah, so we're getting the observation that I've gone through these slides too quickly. I'm happy to share this deck after. Um, the I will send it over, and Terry, maybe we can get that distributed to people. Thanks. Um, Supply chain disruptions, business continuity plans, notification failures, these are all things you need to plan for. Uh, and we, you really need to consider strategically what your biggest vulnerabilities are. This is maybe my closing note. Your business is unique. I have never seen even two very small construction industry built businesses have very different risks and challenges. And you know what your vulnerabilities are. So that's why it's really business planning that is going to be more important than any legal provision. The legal provisions are very important when things fall apart. Uh, I would say your first line of defense is due diligence. Second is contingency planning. Third is pick up the phone. I love that this was an attorney, a seasoned attorney telling me this early in my career while telling a group of people um, that if you've got to eat crow, eat it young. Nobody wants to eat an old, mangy crow. That's probably not tasteful, but or tasty. But if you if you've got to if you've got a problem, pick up the phone and call the counterparty. So many attorneys say don't do it. It's admitting fault. Well, you don't have to admit fault. Say, here's a challenge I'm facing. Don't say I'm in breach of 12A2 sub B in the following ways. You can just say, look, prices are going through the roof, or we've got a hurricane coming in. Let's talk. Let's work through this. Be practical. Don't admit fault, but be open. Have discussions. I was going to go through some real world case studies. I don't have time for that. I don't think they're terribly interesting, but realize great, huge businesses have been devastated by a lack of contingency planning, a lack of thinking ahead, and trying to anticipate the unexpected. I'm now going to open it up to questions.
So there is a question that relates back to one of the early slides from what I can recall. It was when you were highlighting how much wording matters, and you were
Hmm.
talking about the differences between performance being impossible, impracticable, which I have to admit, I did not know impracticable was a word until today. Love that word. Impossible, impracticable, or hindered. For a general contractor trying to manage risk, which tier of phrasing should realistically fight for when negotiating with an owner?
Okay, great question. And maybe also flow downs to subs, right? That's a
Hmm.
similar consideration. So, first of all, I'd like to say impracticable is a real word. Um,
Okay.
but it's different from impractical, and I think it's useful to distinguish that for these purposes. Impracticable means you cannot put it into practice, whereas impractical more is closer to hindered and means it's not reasonable really to put into effect, right? So if something is impractical, um, it's impractical. Like my phone just went off right now in the middle of this conversation. It was impractical for me to take that phone call. It was not impracticable. I could have answered it and ruined this presentation and irritated all of you and shown you great disrespect. So there is a difference, but yeah, that the difference between impossible, impracticable, and hindered is very important. So when you're talking about dealing with an owner, so where you're the service provider, you don't want an impossibility standard on your force majeure clause. You don't only want to be able to invoke it when things are utterly impossible. So you know, something more impracticable is better, something that really affects your flow. Merely hindered, you're never going to get it. A hurricane has caused me a minor inconvenience. I'd like now to stop performance. So, but when you're looking at subs, you also want to be careful what word they're choosing, and that's the probably the takeaway when we're dealing with that question is just uh, make sure that they're not trying to weasel their way out, that you're holding them to a definitive, measurable interference with their ability to perform. You don't, by the way, have to have the word impossible, impracticable, or hindered in the contract. You just need to have a trigger that invokes that idea. So it can just say if is they're unable to perform is basically impossibility, right? If it says interferes with their ability to perform substantially, that's impracticable. Or if it just says uh, makes performance difficult, that's hindered. So just be aware of the terminology or what the be aware that the level of interruption is something to be considered.
That is a really helpful explanation. That's great. Another area of questions is just around cybersecurity. You covered that in the middle portion of the presentation, and I was curious myself, what are some of the common cybersecurity, um, I guess, breaches or difficulties and challenges that you're seeing with your client?
Yeah. Yeah. So I one of the ones is not directly so one of the ones I see the most is not directly a cyber breach that my client has suffered, but where one of their vendors, one of their relationships is affected, so it affects them. So if their bank had a cyber breach, uh, that can affect their ability to make payment. So that's on the one side. Uh, there I'm seeing a lot of indirect effects. I'm trying to think if I've run across anybody being actually hacked and losing access to their database. I don't think I've seen that. But I would say that in your contingency planning, be redundant, back up look, we live in an electronic world. You probably store your documents on the cloud. Maybe some of you still on a server. That's less frequent these days. If you're still on a server, that provides some advantages, but also disadvantages. What happens when the server breaks down? Servers aren't a big thing. When I started my practice, we didn't even have servers. Then, as my law practice matured, we moved to servers, and we thought we were super cool because we had a server. And then over the next few years, we moved to the cloud, where things are stored on some offsite storage facility. Uh, but you ought to be very aware of cybercrime and have good security measures. A lot of you are required to have security protocols in place to take on a job. A lot of you have very sensitive industries. Like I have a client where uh, they can only use US contractors because of security issues. So bear, bear, be aware of the issue, plan around it, and consult with an expert is my recommendation. Not a legal expert, consult. I mean, that's fine too. That's wonderful and probably necessary, but consult with a cyber security organization.
So a follow-up question is, in the absence of anything specifically listed in the contract, who bears the brunt for cyber attacks? The party whose systems were attacked or the party who was misled by the attack?
Yeah, no, that's a great question. And bearing the brunt, I would say the legal obligation, the service provider, unless they have an excuse for non-performance, is totally on the hook. They're in breach if they fail to meet the terms of the contract, regardless of whether it's their fault or not. So that's why you need to plan in your contracts to address it. But bearing the brunt also could be a huge disaster. Picture those of you who are construction managers and one of your subs has a devastating thing, clearly not their fault. They're very well run and they're a key sub and they need to finish their work tomorrow or it's going to cause a major disaster. The fact that they have a great excuse doesn't help you. And who should have the better contingency plan, you or them? I think they're primarily responsible for backup service providers, for backup help, if they're contracting with somebody. But if you're the construction manager, you ought to have backup plans as well. So bearing the brunt of that burden is not a legal concern, uh, so much as a practical concern. So remember, contracts are critical in the dispute phase and navigating the what the parties understood and agreed to do, very critical. But you also have a practical concern of getting a job done where casting legal aspersions at another party and pointing to who's at fault doesn't get the job done. And so, uh, if you see, you know, a disaster happening, and you don't do something to try to stop it, that may hurt you more. That's why we talk about mitigating damages. When you see if let's say that we'll just use this as a metaphor. If you're stalled on the train tracks and the stall was caused by bad manufacturing, a bad car, it doesn't mean you stay in the car and wait to be hit because it's somebody else's fault. When I was a young driver, I used to drive as though fault was all that mattered. I sped, I did all these things, and I had in my mind, well, if they don't pull over, that's their fault. I was, you know, I had some youth poisoning of the brain, but fault doesn't matter when you're trying to get a job done. It's not the primary concern. So mitigate damages, plan, be creative, work with people, get the job done, sort out the legalities later. Most of those claims are not going to expire overnight. I
Okay.
see I'm out of time. It's been a real pleasure. Thank you all. We'll share the deck, and I hope this was useful.
So Chris, one other question. If
Sure.
anyone attending is interested in getting more information from Superlegal, what would you suggest they do? Is visiting your website? What is the best
Yeah,
action
you
to
can go
take?
to superlegal.ai, which is our website. We do what we do is the construction negotiation. We do the redlining of contracts to help get deals done faster. We turn contracts around 24 hours. We use your playbook. So yeah, feel free to reach out. And if you have questions about this presentation, you can reach out to me. And I'm happy to answer any questions I can about the contents. So
Okay, well, thank you so much, Chris. We appreciate it, and thank you to everyone for attending. We will be sending out an email with the slides, and we'll include Chris's contact information as he has invited everyone to ask him questions. So
thank you all.
have a great day. Thank you.